Mr. Hickman.
My Lord, can I pick up my submissions at paragraph 58 of our written case? It's in the key document bundle at page 54. What we say there through to 60 is even if one adopts a different form of analysis in which one treats both the initiating event or the human conduct, as it were, and the secondary consequences as all part of a single composite act, then the result is no different. Section 5 says that the act which causes the harm has to be in the United Kingdom. So even if one adopts that form of analysis, we say Section 5 is perfectly capable of being interpreted in a manner which would not extend immunity to the facts of this case. And we point out at paragraph 60 that there are sections in the State Immunity Act which expressly refer to events occurring wholly or partly in the United Kingdom. In section 3.1b and section 4.1 of the Act. And so
sorry, which sections?
It's at paragraph 60 at 3.1b. This is the section
yes.
my Lord asked me a question about.
Yes, that's it.
And section 4.1 of the Act. So Parliament was perfectly able to say if only part of the Act had to be in the UK, it would have said so expressly. Just in relation to section 3.1b, my Lord, which you asked me about, I'm not sure if this is an answer to the question entirely, but section 3.1b implements Article 4 of the European Convention. So it's, as it were, it's intended to reflect Article 4. So insofar as it crosses that boundary, it's a bit like Article 11 in doing so.
So it doesn't need to rely on Article 24?
No, not my position.
Thank you.
Then we set out a possible alternative interpretation, but that's dependent on treating every single act in the chain as an individual act, which we say is not the correct analysis. And then at 69 onwards, at page 77 of the key documents bundle, we set out some problems with the interpretation of the courts below. And we point out, for instance, 70A.
So before you develop,
yes.
You're still maintaining the alternative?
We maintain that, my Lord, an alternative, but I don't think I need to. And obviously, I'm happy to go through it now, but
it remains part of your case?
Remains part of my case. Everything in my written case remains part of my case, in case there's any. But I want to focus my submissions today, in the limited time I have, on the things I think are going to be most helpful to the court, if that's amenable. So 70A, the notion of acts causing harm adopted below, we say embraces a potentially huge number of acts and omissions. And as I said in answer to a question, every automatic technological operation that's triggered down the chain, as it were, like a series of technological dominoes that is set in train. And in order to try and address that issue, the judge at first instance adopted this qualification of, well, it has to be more than de minimis, a cause that is more than de minimis. But we say there are essentially two problems with that. First of all, it does involve reading words into Section 5 which are not there, because there's a qualification of de minimis acts. And secondly, we say it just represents a confusion of principles of tort law. Because there is no such thing, other than in one exceptional circumstance, where as the cause of harm in tort law being something that is more than de minimis, or being a prerequisite for causation. And that is in the case of industrial diseases, where the courts, including this court, have moved away from the requirement to show but-for causation. So you're in a highly exceptional situation where you've got diseases which are, it's very difficult, if not impossible, to identify the but-for causes. And the courts have said, well, a material contribution, which is more than de minimis, to that injury is sufficient. And just to show you how this works, we've given a couple of references in the bundle at 70B. And can I just ask you to turn up one? It's Holmes and Poton Holdings, which is in the bundle at 1121. And you can see from the head note, actually, sorry, 1100, 1100. And this is somebody who was engaged in cleaning and degreasing engineering components who subsequently developed Parkinson's disease, brought a claim in negligence in respect of all the consequences of having contracted the disease on the basis that the defendant acted in breach of duty by exposing him to unsafe levels of a particular toxin, and that the defendant's breach of duty had caused his contraction of Parkinson's disease. The judge allowed the claim. The defendant's appeal contending the judge had adopted the wrong test for establishing causation of an indivisible disease, namely a disease the severity of which, once contracted, would not be influenced by the total amount of the agent which caused it, by concluding it was sufficient for the claimant to demonstrate that the defendant's breach of duty had made a material contribution to the injury. The Court of Appeal allowed the appeal, properly understood, in the case of an indivisible injury, as well as divisible injuries, which was clear, contracting a disease such as Parkinson's, a tortfeasor who made a material contribution would be liable for the whole of the claimant's injury. And if you turn forward to the paragraph 58 at 1121, in the judgment of Lord Justice Stuart Smith, paragraph 58, he sets out general principles, refers to Lord Roger in Barker and Corus UK, where, although dissenting overall, he articulated the general statement of principle that are not in doubt. Bonington Casting soon became established as the classical authority for the proposition that to succeed and recover damages in full against any defendant, a plaintiff need prove no more than the defendant's wrongful act materially contributed to his injury. Since anything above de minimis will do, this means that a claimant can succeed even though the injury would have occurred without the defendant's act. The but-for or sine qua non test of causation gives way to this considerably more generous test based on a material contribution to the injury. And I would, not now, but if I do rely on 58, 59, 60 and 62. But the essential point is that we're in a highly exceptional area where one is not looking for whether but for an act in injury would have been suffered. Whether the defendant's act caused the injury in the sense that it was a but-for cause of the injury. And it's only in that context where one moves away from that basic causal premise that one has this test of more than a de minimis cause or more than a de minimis contribution. And we say it has no relevance anywhere else in tort law. And clearly, that notion of materially contributing has no relevance whatsoever to the interpretation of Section 5. And the fact that the judge has lent on this concept of more than de minimis tells you something's gone wrong in the interpretation of Section 5. Because caused by an act is a perfectly comprehensible and straightforward statement, and that makes sense in the context of ordinary tort law principles.
So if you said but-for causation, that would be more acceptable, would it?
I'm sorry, Mark.
If you said but-for causation, that would be more...
Well, it probably has to be more than but-for causation, because obviously you can have a but-for cause which is not identified as the cause in tort law. It's that is a necessary but not sufficient condition for identifying a cause in tort law. I think Lord Leggett possibly is the example of the mountaineers injured knee in a case. And
I think Lord Hoffman must be credited with that.
Oh, and it was Lord Hoffman's injured mountaineer. Sorry. But that's the example that's given to show that you don't. So,
I'm not sure I'm understanding the point. Your submission is that while on normal principles of causation, setting aside the exceptional cases, it would be necessary to show that it was a material cause.
no, you have to show that it was the cause. Or if, I mean, so...
An effective cause, a but-for clause, at least.
Exactly. At least the but-for clause,
yes.
and then the responsible cause in law. But in the normal causation inquiry, one doesn't deal with more than de minimis. That's simply a concept that is unknown to causation, other than in a highly exceptional circumstance where you're departing from ordinary principles.
Yes.
And the fact that the judge has imported it in here is entirely out of place. And it demonstrates in our submission that the act which the courts below have identified as what they call causally significant is not the act that causes the harm. They are simply events along the chain, which is not, when you're adopting an ordinary tort law analysis, what you would identify as...
It's a bit odd, though, because all the events along the chain are but-for causes, one would have thought, of the outcome.
Also,
I mean, the judge has just gone off on a bit of a frolic here, hasn't he?
my lord, yes.
And the Court of Appeal didn't talk about de minimis.
The Court of Appeal doesn't talk about de minimis, but then that gives rise to the problem identified in 70A, because if you don't have some kind of control, you end up with everything.
The control is that it has to be causative. That's the control. In the UK, and causative of the requisite harm.
Well, but the causative is not the test in the statute.
Yes, it is.
Well, the statute requires that it is an act, it is harm caused by an act.
Yes. So
And
it has to be a causative act in the UK.
Well, we submit that, for example, on the case of, say, somebody firing a missile over a border, the harm would be caused by the firing of the missile. Okay, it's not necessarily every event that necessarily follows the missile landing.
You're distinguishing now between the act and the effect. The act. That's,
well, yeah, that's
really
one way of putting it.
That's the critical point,
critical
isn't it? I'm not sure that, following the missile after it's set off along its trajectory is going to, breaking that down is going to help very much. Either one accepts the point that it's the human act that is the act, or you don't.
Well, my lord, that's, with respect, we accept that analysis. So,
can I
yes.
just be clear I understand? So in paragraph 70A, you are positing that a problem is that there would be a potentially huge number of acts and omissions which caused harm, only one of which needs to be taking place in the UK. Are you sort of thinking that you might have a computer in Bahrain, a computer in the UK, and a computer, let's say, in Germany,
yes.
and the harm is actually suffered in Germany,
Yes.
but you would say that you are caught by Section 5 because there's an act or omission in the UK on the counter-argument to what the one you're putting forward is, because it goes through a computer.
If you're routing through the UK computer, exactly. Or
and that can't possibly be right. So that explains why Mr. Justice Julian Knowles had to say, but it's got to be more than de minimis.
Yes.
So that's the sort of example you're
Exactly,
thinking of, is it?
exactly.
Yeah,
Yes.
okay. And you say, well, that's reading something in, but your main submission is you only get into that mess because you're not reading act or omission correctly.
Exactly. That's exactly it, my lord. So then previous authorities, you will have seen that the judge said he drew some support from the Heisa case, and we say that really no support can be drawn from that case. If anything, it supports us, although it probably, I mean, it doesn't go far enough, as it were, to answer the point in issue before this appeal. Perhaps we can have a very brief look at it. It's in the bundle. I'm sorry, I've just lost my note. 1044. So the issue arose in this case in a slightly convoluted way. In order to enforce certain US judgments in favour of US citizens injured in terrorist attacks, the claimants had to show that the court in England and Wales would have jurisdiction under the Civil Jurisdictions Judgment Act 1982, following an initial ex parte hearing before Mr Justice Singh, which you may have seen referred to in the judgments below as well, on an application for service out, which we say decided only that there was a properly arguable basis for the claim. The judgment of Mr Justice Stewart, which we have in the bundle, dealt fully with the application of Section 5, and he had regard to the concept of transnational torts in that context. The claimants argued that Section 5 applied to a composite act or omission, i.e. an act occurring partly inside and partly outside the forum state, and that a state had no immunity even when a state's agents were outside the United Kingdom. If you pick it up at 147 of the bundle, sorry, paragraph 147, which is 1044, and you can see the submission that's being made by the claimants, and examples of shooting a gun across a border, planting a bomb on a train, etc. And the issue here was there were a number of terrorist attacks, only one of which, well, all of them except for one, that was called the Acosta judgment. You see that in paragraph 146. They all involved acts or omissions committed in Middle Eastern states, so outside the United States. But it was said that there were victims in the United States because people had suffered mental injuries. And the claimant's submission is set out at paragraph 147, and the claimant's submission in the middle of that paragraph, they say that in all of those cases, shooting across borders, etc., would be within Section 5. And at the next paragraph, the judge says the difficulty with this submission is that Section 5 of the 1978 Act is not concerned with where the substance of the tort is committed. It is concerned with where the act or omission causing death, personal injury or damage occurred. In this case, did it occur in the United States? Here, apart from the Acosta case, that was an attack on the United States, all relevant acts or omissions occurred in the Middle Eastern states. The fact that either primary victims continued to suffer injury on return or secondary victims never left the United States does not assist the claimants. Section 5 does not permit aligning the act or omission causing the personal injury with where the personal injury occurs. I do not accept that Section 5 can be construed with such flexibility as to permit the claimant's submissions to succeed. And then the judge, we say correctly, has regard to Article 11 and says that it supports that analysis. And then finally, at the end of paragraph 152...
So, sorry, there were no acts in the UK there. It was just, there were there were victims, yes, either primary or secondary.
Yes, and he goes on, exactly, but its effects were being caused because of the secondary victims never left the United States, so they said they suffered damage, as it were, from learning about or seeing these attacks.
So there were no acts at all outside Iran?
In this case, yes.
Yeah.
He doesn't address this case, does he?
He doesn't, so he doesn't address...
Paragraph 160 is...
He doesn't, and exactly, but I was just about to show you 160. So he basically says, I don't need to decide cases. But it doesn't... it does not provide any support for the respondent's case, contrary to what the judge found at first instance. And we submit the approach taken by the judge, if anything, leans in support of our case.
But it does say at paragraph 152, I'm not saying that section 5 replicates article 11, it clearly does not. For example, it does not have a presence requirement. I mean,
yes.
To that extent, it's supportive of the way the Court of Appeal was putting the matter.
Well, yes, my lord, but I see that, yes, but you have my submissions on that point.
Yeah.
In terms of other supports, we have pointed in our case to a few secondary materials, and we say again they do provide some support for our position, but what they do show, we submit, is that it can't be said that there is a clear and unambiguous reading of Section 5, which is essentially the reasoning of the courts below. So can I show you first of all page 322 7 of the bundle. So this is an article by Hazel Fox, Lady Fox, State Responsibility and Tort Proceedings Against a Foreign State in Municipal Courts. It's at 3205, and the passage that I want to show you is at 3227. And this is in a section dealing with the tort exception to state immunity, and two-thirds of the way down the page, she says the wording of the English statute would seem to prevent immunity where the act attributable to foreign state is performed outside the country. So cross-border acts of terrorism, such as the placing of an explosive device in a letter posted abroad, or a bomb in a foreign airport or an aircraft flying through the UK, would not be covered. Does such a limitation therefore prevent an English court from exercising jurisdiction in cases such as the Lockerbie disaster? She goes on to consider that and comes up with some possible analyses which would allow jurisdiction to be exercised in those contexts. At 3067 of the bundle, we have cited Dicey, Morris and Collins.
Sorry, just in terms of what's she saying about the Lockerbie disaster?
Well, she goes
you would
on.
Need an amendment to Section 5.
Yes, or she comes up with an analysis that says, well, you could say, well, the essence of the tort is in the UK, but we say that's clearly not the correct approach, and that is a sort of expansive reading. But the point is, yeah, there's different. Sorry, so I was at 3067. So this is Dicey, Morris and Collins, Section 5 of the 1978 Act. And then within paragraph 9-050, last full sentence on the page, exception 4 concerns acts or omissions in the United Kingdom, does not involve consideration of the place where the substance of the wrong occurred. It has not been decided whether exception 4 applies to acts of foreign states which are jure imperii. Well, that has been decided because that's the Al-Masseria case. And then at the end of that paragraph, so we're now on page 3068, final sentence, consequently, if agents of a foreign state on an intelligence mission in England commit acts within England that cause personal injury or death to someone in England, then neither they nor their foreign state will be entitled to immunity. And there's an illustration, and the second illustration is such an example. Now, again, we say that that leans towards our interpretation, but it doesn't. I have to accept squarely, confront it. What it doesn't do is provide any support to the respondents' case. And then finally, at 3078,
I'm sorry, the page reference again?
3078.
Thank you.
This is a book, State Immunity, Selected Materials and Commentary by Dixon, Lindsay and Lunam. And at 3078, at paragraph 4.052, the authors address the wording caused by an act or omission in the United Kingdom. Perhaps I can just ask you to read that paragraph down to the end of little a. So again, we say that's supportive of our analysis, but in any event, what those authorities, secondary authorities, show is that it can't be said that the section is clear and unambiguous and can be interpreted without regard to its context and purpose. Can I ask you to turn up the respondent's written case, please, at paragraph 36. This is the respondents' submissions in writing, as it were, on some of the, they say, the problems with our analysis, and as a response to our submission that arbitrary results are produced by the judgments below. And what the respondents say, first of all, at paragraph 36, this is page 111 of the key documents bundle, is that second sentence, if the state chooses to infiltrate inherently mobile devices with the intent that they may be accessed anywhere in the world, there is nothing arbitrary or unfair in principle about it being held accountable for the interference with territorial sovereignty that must have been at least reasonably in contemplation from the outset. Well, we say that's not the correct form of analysis. It's not a question of whether it would be arbitrary, unfair, and in any event, we point to the fact that, as I've said this morning, covert surveillance characteristically will attract immunity because it's only personal injury and property damage that falls into the exception for immunity. So to say that, well, you can't complain, or there's something inherently correct about hacking being subject to jurisdiction of local courts is, we say, a step too far and proves too much.
And what do you say about their examples of paragraph 37?
Yes, so paragraph 37A, on the so I'm reading now from the second sentence. On the appellant's interpretation of Section 5, there would be immunity if a murder were committed by a drone attack in UK territory or detonation of an explosive device in the UK. Okay, so this is the over the border.
Yeah.
What we say is that's correct. Yeah. That is a line, but that is not arbitrary. That is a line that is well recognised and well trodden in international law. I took you to the international law commission's draft articles on state responsibility, where they're absolutely explicit that there is a distinction in international law between going into someone's territory and detonating a bomb and launching it from outside the territory. And that is where the line has been drawn to accommodate the competing imperatives of recognising the sovereign equality of states and territorial sovereignty. And once things are happening outside your territory, you can't exert jurisdiction over them. And that's a principled line, we say, in international law.
I mean, it's indisputable. That's what Article 11
And it's
will give you.
That's a
I mean, to say it's on principle means that Article 11 is on principle.
That's our point.
Well, it can be said to produce results that do seem rather arbitrary, because, but on the other hand, once you start extending over the border, then you're going to be drawing some arbitrary distinctions. It may equally be said, where do you stop?
Well, and also, it isn't arbitrary, we say, for a state, as it were, to assert jurisdiction over things that have happened in its territory. But once you're including within that things that happen in a foreign state's territory, you're into a different, significantly different situation. So the UK asserting jurisdiction over events that have happened here, allegedly in Bahrain, in government offices or wherever they might have been, that's a significantly different situation from an international law perspective than situations that are wholly internal. So it's not arbitrary, we say. The courts below, as we've seen, rejected the relevance of the European Convention on State Immunity, essentially because the wording of various articles differ and because it diverges in various respects, or the State Immunity Act diverges in various respects from the European Convention on State Immunity. However, there is a clear explanation for departures from the European Convention, which is the declaration made by the United Kingdom under Article 24, which permits it to have exceptions that are broader than those in 1 to 13, as long as they don't prejudice the immunity of states in respect of their sovereign acts. And that explanation was not considered by the courts below, but it does, in our submission, account for the main differences, at least, between the two instruments. So the bill, as it was introduced to Parliament, is in the bundle at 2159, and one can see that it marched more closely in step with the European Convention on State Immunity. And as we set out in our written case, at paragraph 85 on page 83 of the key documents bundle.
Sorry, your written case, paragraph?
85.
Thank you.
So we quote a passage from Fox and Webb's book, The Law of State Immunity. The State Immunity Bill initially followed closely the scheme of the European Convention, but the government introduced significant amendments during the passage through Parliament, particularly to meet concerns that the exception for commercial matters was insufficiently broad. And I've shown you that in the European Convention there are very narrow exceptions in relation to commercial matters. And you can do a compare and contrast from the original bill to what appeared in the subsequent Act, and there were undoubtedly some exceptions that were different and much broader than those in the European Convention on State Immunity. And we refer there to the way, in particular, that the commercial exception was broadened, but there were others, and we refer to them. But the inclusion of these provisions did not result in any breach of the United Kingdom's obligations under the European Convention. And therefore, it's wrong to infer that such departures from the terms used in the European Convention reflect an intention on the part of Parliament to deviate from its international obligations. The provisions of the State Immunity Act were consistent with the United Kingdom's treaty obligations because of the effect of Article 24.1 and the declaration that the United Kingdom had made. Now, we can see that the United Kingdom did not originally propose to make such a declaration, but had done so because of those changes, and we get that from 2271 of the bundle.
So what are we looking at now?
2271.
What is it?
This is the notes on clauses document.
No, this is the document to which objection is taken, I think.
This is the document to which objection is taken. So I ask you to read the Benny essay, as it were. Considerable reliance was placed on this.
Objection to you. Thank you very much.
Which page, sorry?
2271.
Thank you.
Considerable reliance was placed on this document below, but I'm not relying on it, as it were, for those purposes. I'm pointing you to a different part, which just explains, right, as it were, how the declaration came to be made. It's at 2271, and the relevant, it's under the heading Chapter 4 in point 10, and the relevant passage starts with the sentence, the United Kingdom did not originally propose to make a declaration, and it's about 4/5 of the way down the page. Yeah. Could I just ask you to read that to the bottom of the page?
The 3 and 4 correspond to sections 3 and 4, clauses 3 and 4.
Yes, let's turn them up so that there's no...
Clause 6 was the personal injury clause.
That's right. And it became section 5 because clauses 3 and 4 were two discrete commercial exceptions which got combined into one more general commercial exception, which is currently in section 3. So then all the numbering went down by one after section 3.
So what's the significance of this paragraph?
Well, it's just explaining that the declaration was made to accommodate
a commercial exception.
A commercial exception, and to deal with those changes that were made during the passage of the bill through Parliament. Section 5 was not amended in any material way. So we say that section 24 undermines the arguments that were accepted in the courts below, that because of deviations between the provisions in the European Convention on State Immunity, in particular the exceptions, and those contained in the State Immunity Act, one does not need to apply the presumption that Parliament was intending to comply in full with its international obligations. Because of the departure from the terms of the ECSI, the courts below essentially put aside the European Convention, said it was not of assistance as an aid to construction. But we say, well, that might be right in relation to those clauses that were widened and that are justified under Article 24, the declaration under Article 24. In fact, it clearly is right. It definitely does not have as much importance as an interpretive aid in relation to those clauses that have been widened under Article 24.
I thought the Article 24 argument wasn't run below.
It wasn't.
So what the Court of Appeal said is that Section 5 is so clear and unambiguous that even if there is a divergence,
Yes.
the presumption doesn't apply. You don't override the words of the domestic legislation
Yes.
by reference to an international treaty.
Yes.
The domestic legislation
Yes, but
stands.
the Court of-
So I'm not sure, maybe haven't followed the
Well,
point
the
you're making.
Court of Appeal also said that because there are various sections of the State Immunity Act which
Yes.
don't correspond
Yes.
to the European Convention, therefore that reinforced its point that the European Convention is not an aid to construction. It had two limbs to its
Right, okay.
argument. One was based
But it
specifically
wasn't an
on...
Article 24 limb. It was a broader... this Act wasn't intended to
Yes.
replicate...
You're saying they
exactly.
overlooked Article 24,
Yes.
Yes.
and they thought that the discrepancy between the two showed generally that the UK wasn't too concerned to comply with the
Yeah.
convention.
And
But once you look at Article 24, you can see that all the differences that there are in fact compatible with the convention.
yes, and compatible with the United Kingdom's international
Yeah.
obligations. Exactly, my lord. And so, sorry, just to come back on one point that just escaped me for a second to my lady's question. I showed you as we went through the judgments that both the First Instance Court and the Court of Appeal have relied on comments by the Privy Council, by Lord Jones, about the fact that the State Immunity Act only sort of broadly reflects the phraseology of the European Convention. But what I'm trying to do is explain there's a very good reason for that. They're not inaccurate statements. They just don't lead to the conclusion that the courts below thought they did, which was therefore Parliament wasn't really that concerned about sailing very close to the wind of its international obligations. That's the point.
Thank you.
What is the respondent's position in relation to this? Can we turn back to the respondent's case 54 to 55 at page 121? This is where they respond to this point, where we say, well, you can't rely on Article 24 when it comes to Section 5 because you're expanding it into the realm of sovereign acts. And they deal with this point at 54. The appellant seeks to avoid this outcome by emphasising the final sentence of the United Kingdom's declaration, which states that the declaration is without prejudice to the immunity from jurisdiction which foreign states enjoy in respect of acts performed in the exercise of sovereign authority. But that qualification does not, as the appellant argues, carve out of the United Kingdom's derogation all acta jure imperii. The qualification only extends to sovereign acts insofar as they are the subject of immunity according to general principles of international law, such as the immunity for acta jure imperii committed by armed forces during armed conflict, as confirmed in the jurisdiction and immunities case. So, the argument seems to be that, yes, we're right that interpreting Section 5 in the manner that the courts below did will interfere with acts of a sovereign nature, sovereign governmental acts. But they are not acts covered by the customary international law rule of immunity. That seems to be the argument. But we say that is an impossible argument to sustain. In the jurisdiction and immunities judgment in the ICJ, it was argued by Italy that there is an exception to customary international law, the rule of sovereign immunity for sovereign acts in customary international law, that there is an exception relating to tort claims for personal injury and property damage, which, as I mentioned this morning, the court did not decide. However, the whole premise of that argument is based on two critical instruments. the European Convention on State Immunity, Article 11, and the UN Convention on Immunities, Article 12. And as I explained this morning, both of those articles are as clear can be that they exclude transnational torts.
But not so, but they could, transnational, but isn't this about sovereignty? Sorry. No,
Well, you say they both exclude transnational torts. You've shown us material. Well, because of the express provision of each.
Yeah.
Yes, because of the express terms of those articles, and also what's said by the International Law Commission in their...
But the exception applies to sovereign acts and private acts in Article.
The exception applies to sovereign acts and private acts, but only where they're wholly committed within the forum state.
You say the starting point is that sovereign acts are immune, but that has possibly been qualified by an exception that's been established at an international level by the UN Convention and the European Convention.
Yes.
That says sovereign acts that are not immune insofar as they're within those provisions where there's physical presence and tort committed within the foreign territory.
Yeah.
But no further.
Exactly, my lord. Can I perhaps...
And that you say is confirmed by the way the argument went in the jurisdictional immunities case.
Yes. I mean, there was no suggestion in that case that there was a wider immunity, exception to immunity than Article 11, Article 12. Can I take as a starting point?
The point was left open, wasn't it?
I'm sorry, my lord?
The point was left open.
Yeah, I'll come back and I'll show you exactly.
But it was dealt with on the basis of military armed conflict.
Yes. Okay. Let me build this up from the ground upwards, as it were. When we turn back to Benkabush 696 of the bundle, paragraph 37. So, the end of that sentence, the rule of customary international law is that a state is entitled to immunity only in respect of acts done in the exercise of sovereign authority. You can take out the word only because that's dealing with the submission that there was a wider. So in respect of sovereignty. So that's the basic starting point. In the absence of a special rule to some different effect applicable to employees in the position of Miss Janet and Mr Benkabush, that is the default position. And that is the default position. So what you need to have is some special rule or exception which, as it were, eats in to that default position. And what that requires, we say, is a new customary international law rule with widespread and accepted state practice to support it, coupled with opinio juris. And if we then turn to the ICJ...
Can it work that a rule of international law loses its customary status because, although no opposite rule, as it were, is established, it ceases to be universal state practice supported by opinio juris?
My lord, that's not the way that this court addressed it in Benkabush. The exception had to be established itself by state practice. But even assuming you're right about that, there's still no evidence to support such a rule, and I will explain why.
what do you say the answer in principle is to my question, just as a matter of interest?
In my submission, you would have to demonstrate essentially a new customary international law rule. So you would have to demonstrate that there was a near universal state practice. And that is in part because in the Benkabush case, as Lord Sumption explained, the customary international law rule, that is the restrictive doctrine, is based as much on principle as it is on state practice.
Okay.
It's built on principle, it's not built on state practice. So you need state practice, as it were, to erode it. So if you take up the jurisdictional immunities case, which is at the relevant part of it anyway, is at 2633. Paragraph 62. Paragraph 62. The essence of the first Italian, 2633. The essence of the first Italian argument is that customary international law has developed to the point where a state is no longer entitled to immunity in respect of acts occasioning death, personal injury or damage to property on the territory of the former forum state. We read that as being acts on the forum, in the territory of the forum state, even if the act in question was performed jure imperie. Italy recognises that this argument is applicable only to those of the claims brought before the Italian courts, which concern acts that occurred in Italy, and so forth. In support of its argument, Italy points to the adoption of Article 11 of the European Convention and Article 12 of the United Nations Convention, and to the fact that 9 of the 10 states it identifies which have adopted legislation specifically dealing with state immunity, the exception being Pakistan, have enacted provisions similar to those in those conventions. Italy acknowledges that the European Convention contains a provision to the effect that the Convention is not applicable to acts of armed forces, but maintains that the provision is merely a saving, and so forth. And then if you look down, you see the states. Towards the bottom, Italy also notes that 2 of the national statutes, those of the United Kingdom and Singapore, are not applicable to the Act of Foreign Armed Forces. But you can see the states that Italy is relying on in terms of the relevant state practices: UK, Singapore, Australia, Canada, Israel, Japan, South Africa. Now, the critical point about this argument, which the court doesn't determine, I'll just show you the court doesn't determine it. That's at 65 over the page, 2634. The court considers it's not called upon in the present proceedings to resolve the question of whether there's customary international law, a tort exception, applicable to act jure imperie in general, okay, because it's dealing with armed forces. Okay, so it doesn't have to decide the point. But my point is that the entire premise of this argument that there's an exception is built upon Article 11 and Article 12. Article 11 of the European Convention on State Immunity and Article 12 of the UN Convention. And therefore, it cannot be wider than those articles.
Well, it could, but it would be an incredibly bold submission, you'd say.
Well, yes. Well, that is the submission that's being made, I think. Insofar as there is state practice identified, it is identified in those articles and in the national provisions, some of which we have before us, which I'll address you on in a minute. But none of those go as far as to recognise an exception that would apply to this case. Because Article 11 and Article 12 are bounded by the need for the acts to be within the state. And we saw that the International Law Commission's draft article saying we're requiring that the tortfeasor be in the state to ensure that there's no possibility of this exception applying to a transnational tort.
Is there any country that's gone further, if you leave aside the question whether we have, which is what we're arguing about?
Not that anybody's identified. There are, I'll go through the national provisions very quickly, which are cited by my learned friend, but there is nothing. There is no basis at all for this court, even if Italy was correct that there is an exception to the principle of immunity for acts jure imperie. There is no basis whatsoever to find that it goes wider than Article 12, such that it could apply to a case such as the present. And as I started off by saying this morning, there is no case anywhere in the world in which a case such as this has been subject to the adjudication of domestic courts. My lords, my lady, I have a section in the written case dealing with the reliance by the courts below on general considerations of justice. In light of the submissions I made this morning, I don't think I need to go through that in any, again, or in any more detail. I think you have my points on that. We say that courts below both relied impermissibly on their own notions of what justice required. So in which case that brings me to the US cases. The Foreign Sovereign Immunities Act 1976 in section 1604 sets out a general immunity for states. Section 1605 sets out exceptions, including what's called the non-commercial tort exception, and that's in the bundle at 2910. So, 1605, little a, a foreign state shall not be immune from the jurisdiction of the courts in the United States or the states in any case, and then subparagraph 2 sets out commercial activity exception, and then subparagraph 5 says it not otherwise encompassed in paragraph 2, in which money damages are sought against a foreign state for personal injury, death, or damage to or loss of property occurring in the United States and caused by the tortious act or omission of that foreign state or of any official or employee of that foreign state while acting in the scope of his office or employment. And then there's a couple of, as it were, exceptions to the exception. Now, one might think, reading that suggests that there could be an extraterritorial tort exception in the United States, but the US courts have categorically rejected that submission. The relevant case law is set out and summarized in the judgment of the US District Court for the Southern District of New York in the Democratic National Committee case against the Russian Federation in 2019, and that's at 2948 of the bundle. If you look at the little paragraph headed background, you can pick up the basic facts.
You're going to have to give me the page reference again. Sorry.
2948, my lord.
Thank you.
So this was an action against the Russian Federation and a number of others into alleged unlawful hacking into the plaintiff's computers in connection with the 2016 presidential election, and thereafter publicly distributing materials. The reasoning is in part 6 of the, sorry, part 4 of the judgment, 2964.
Sorry.
2964, my lord.
Thank you.
You can see that under part 4, the Russian Federation had not appeared but had submitted a statement of immunity. Then the court under A sets out the basic framework, and you can see it over the page at 2965, the Democratic National Committee asserted 2 exceptions, one of which was the non-commercial tort exception, which we've looked at. Then under B, if you go down B, there's a sentence towards the bottom which says, courts read this exception narrowly. Indeed, Congress's objective in enacting the non-commercial tort exception was to eliminate the foreign state's immunity for traffic accidents and other torts committed.
I'm so sorry, I can't find where you're reading from.
2965, my lady.
Yes.
And then under B,
Yep.
and then it's about just over half the way through
Yes, I
that
see.
column.
Yep.
Courts read this exception narrowly.
Yeah, thank you.
And perhaps can I ask you to read, I know it's a long passage, but can I ask you to read all the rest of page 2965 and all the way through to C on 2966, rather than, as it were, walk you through it. I'm sorry to ask you.
Sorry, from the reference to Amarada Hess onwards.
2965, my lord. Under B, I read the passage towards the bottom that begins, courts read this exception narrowly.
Yes.
And perhaps I can just ask you to read the rest of 2965 and 2966 through to heading C. So the way it's encapsulated by the US courts, US federal courts, is that the entire court, including not only the injury, but the act precipitating that injury, must occur in the United States. And then on page 2966, in the first column on the left, it said, because the theft was planned and executed from computers in Russia, it is plain that the entire tort did not take place in the United States. That's because the acts precipitating did not take place in the United States. And then at the bottom of that paragraph, the court found, so that column, the court found that the tortious intent of targeting the plaintiff and the tortious acts of computer programming and sending the infected email took place outside the United States, and so forth. Talking there about Doe and Ethiopia. These are the basic principles. So the court goes on to find that the non-commercial tort exception obviously is not applicable on the facts of that case. Now, there's one other point that we can obtain from the US cases, and that's apparent in the case of Doe or Kidane against Ethiopia, and that's at 2990. And this is a case, we've got the first instance judgment and the Court of Appeal judgment. And the relevant part, this is again a computer hacking case. And if you turn to 3002, whether there's a heading, whether the tort occurred in the United States, and the court sets out the principles. And if we go through to 3005, in the first column on the left-hand side, in almost the centre of the page, the court identifies three considerations which convince the court that Ethiopia's view is more compelling, and that's the view that the tort took place outside the United States and was within...
Sorry, it's the first column on the left on...
Yes.
3005.
Yes.
3005.
3005. So there's 3 points. The court is making 3 points. The first point, which is not the point that I want to emphasise, but you will see the first point is the question of whether the entire tort occurred cannot be wholly divorced from the physical location of the tortfeasors. So that's the first point that's made. And then the court goes on and considers that for several, over several paragraphs. If you go through to pick up the second and third points, these begin at 3007, and almost at the top of the column on the right-hand side. Second, to the extent that it is uncertain whether Congress intended to permit suit in the US courts for torts precipitated from abroad, the DC Circuit has cautioned against converting the non-commercial tort exception into a broad exception for all alleged torts that bear some relationship to the United States. And then halfway down that column, the court, moreover, must proceed cautiously where application of the exception would arguably shift the balance that Congress struck between the desire to afford members of the public a remedy for torts committed in the United States by foreign employees and officials and the interest of maintaining comity with foreign states. Applying the exception to torts precipitated exclusively beyond the borders of the United States by tortfeasors who neither set foot in this country nor directly caused the tort to be committed here. I think that's talking about people. They send someone abroad. Implicates that balance. And then at the bottom of the page, put differently, the question whether to afford a foreign state immunity from suit is inherently involves political judgment, raising sensitive issues of foreign relations. And then the third point, the judge says third, this is 2/3 of the way down, page 3008. And finally, the legislative history of the non-commercial tort exception, although limited, provides additional support for the conclusion that Congress did not intend...
I'm sorry, the third point starts where? 30...
It's on the left-hand column of page 3008.
About 2/3 of the way
yes,
down.
got it,
2/3 of
got
the
it,
way down.
thanks.
The inventive paragraph numbering on UK cases has greatly simplified this process, hasn't it? And then it said, one of the primary goals of the FSIA to bring the US rules of foreign sovereign immunity in line with the practice of other nations, and in particular to subject foreign states that commit torts in the United States to the same rules of immunity as applied against the United States abroad. And then in the next paragraph, there's a paragraph, sorry, the next column, there's a paragraph that begins, this same legislative history also reflects an understanding of the European model that Congress sought to mirror. In particular, the legislative record included a copy of the European Convention on State Immunity, which was scheduled to come into force roughly a week later. When asked at a hearing whether there was any inconsistency between the new convention and the bill that became the FSIA, the legal advisor to the State Department answered no, with the sole qualification that the FSIA went something further regarding the execution of judgments against foreign states. The relevant provisions of the European Convention on State Immunity provided, and then it sets out. So there's express reliance on the European Convention on State Immunity and the desire for a harmonious approach amongst states on questions of immunity.
It might be said that the US legislation focuses on the place where the damage or harm was caused,
but they've not,
whereas the European Convention does not, on the place of the conduct. So that's a rather surprising answer, isn't it?
Well, you can see that the force of the international consensus has had on the interpretation of that statute. And of course, they also emphasise their own legislative history and so forth, the words of that statute. But it's at least one of the factors that has influenced the courts in the United States.
I can see why you're relying on it, but the question was whether there was any inconsistency between the new convention and the bill that became the FSIA, and that's one rather important difference, isn't it?
Well, the way that the courts have interpreted the legislation so that it doesn't apply to transnational torts, because Article 11 clearly doesn't. And
I mean, the US is a narrower incursion on sovereign immunity than the European, because it requires the damage as well as it requires everything to be in the US.
My lord, that's correct. Yeah, that is correct. But we
Can I just ask about that? Because just in my mind, in Section 5 of the 1978 English legislation that we're primarily focusing on, I am assuming that the death or the personal injury can occur outside the United Kingdom. That's correct, is it?
Yes.
Yeah. Thank you.
And that went on appeal to the Court of Appeals, and that's in the next tab at 3013. And just to pick up briefly from this judgment at 3016, the column on the right-hand side, two-thirds of the way down, the court says there is no tort without intentional intrusion, whether in London, Ethiopia or elsewhere. The tortious intent aimed at Kidane plainly lay abroad, and the tortious acts of computer programming likewise occurred abroad. Moreover, Ethiopia's placement of the FinSpy virus on Kidane's computer, although completed in the United States when Kidane opened the infected email attachment, began outside the United States, and thus cannot be said that the entire tort occurred in the United States. And then over the page at 3017, just to show you that there was an endorsement, albeit more briefly, of the reasoning in relation to Article 11 and the need to keep in harmony with the European states. And you can see that in the passage that begins in the left-hand column in the final paragraph, and it runs over the page. And there's a footnote, footnote 6, which refers to the confirmation that there was no intentional difference between the FSIA and the European Convention, footnote 6. So it's dealt with much more shortly in the Court of Appeals judgment, but they effectively endorsed the point that was made by the judge below.
The passage in the text that you rely on is the right-hand column?
It starts on the left-hand column bottom.
Yeah, Kid in regard.
Yes, and then it runs over into the other page.
Thank you.
So we say those authorities are helpful for a number of reasons. They demonstrate that the question of where the tort occurred cannot be divorced from the location of the tortfeasor. And the precipitating act. We say, make a powerful point in respect of the court needing to proceed cautiously in this area, and therefore adopting an interpretation which is narrower. Parliament wishes to broaden it if it can. And thirdly, given the reliance on the European Convention in that case law, and the importance of a harmonious interpretation, we say that adds force to our interpretive argument. Decisions of the US courts on the FSIA have been treated, as you've seen from the quotes in our written case, as of authority. They're not of authority, but they are persuasive, and they have been considered in several cases. And of course, there's different wording, and of course they need to be handled with care, but we do say that they do provide support for our argument. And of course, finally, the point that I made at the beginning, that there is no case law which extends the jurisdiction of a domestic court to acts such as those in this case, and in the jurisdiction in which there's been a considerable amount of litigation of directly analogous case law. Those cases have all been dismissed on the basis of state immunity. The Canadian State Immunity Act is set out at 2725 of the bundle. Section 6. Foreign state is not immune from the jurisdiction of a court in any proceedings that relate to any death or personal or bodily injury or damage to loss or property that occurs in Canada. That was considered in the case of Kazemi, and that case is at 2767, the bundle.
So that again focuses
2767.
That again focuses
Oh, I'm sorry.
on the place of the harm or the damage.
Yes.
No. And we're going to 2767?
Yes. This was a case that concerned the torture and murder of a Canadian journalist in Iran in 2003. The claim was brought against Iran by the estate and also by the journalist's son for psychiatric damage, the son having been in Canada throughout the relevant period. The claim by the estate was dismissed on the basis that the death and personal injury had occurred in Iran. The son's claim went to the Supreme Court, and he claimed that his personal injuries had occurred in Canada. Justice Lebel, giving the judgment of the court, or 6 members of the court, there was 1 dissent, held that the acts constituting the tort and not just the harm must occur in Canada. And you pick that up at paragraphs 69 and 70 of the court's judgment, 2767 and 2768. Perhaps I can just ask you to read those 2 paragraphs, please.
Yes.
So 2 points from that, my Lord. First of all, that despite, as my Lord noted, the orientation of the wording, again, another example of the courts bringing it back down to a sort of territorial Act requirement. Although the facts of this case clearly are not the same as ours, because this is a case where psychiatric harm, it wasn't said that anything physical happened within Canadian territory. Nonetheless, if you look at the reasoning of the court, the end of paragraph 70, and one of their core reasons for interpreting the provision in the way they do, is that if they don't, such a situation would put the foreign state's decisions and actions in its own territory directly under the scrutiny of the Canadian judiciary, the exact situation sovereign equality seeks to avoid. And so we say that reasoning would apply directly to the sort of case that we are concerned with, and it applies to this case.
You might have thought on its first reading that the Canadian statute would be much more helpful to the claimants here if we had that wording, because it just, on the face of it, just requires the personal injury to be here.
Yes, ma'am.
But they've read into it, you're saying, a requirement that the Act occurs in Canada as well.
Yeah. In a similar way to the US courts. Then at paragraph 77 of the Respondents' written case, there's a reference to, this is at 127 and 128 of the key documents bundle. There's a reference to various other countries. The first one is Australia, but the Australian provision, when you've got the reference there, we don't need to turn it up, but that just mirrors the UK statute, so that doesn't take matters any further. There's no case law that anyone's been able to identify interpreting it. Then you have Japan. Japan's statute, when you look at it, it simply incorporates almost word for word, if not word for word, Article 12 of the UN Convention. Japan signed the convention in 2007 and then enacted essentially its law on immunities, including Article 10, which reflects Article 12 of the UN Convention. So it includes the requirement that there's got to be a tortfeasor on the territory, and then it ratified the UN Convention in 2010. So the Japanese statute, again, doesn't assist the respondents, because all it does is incorporate Article 12 of the UN Convention, which common ground would not apply to this claim. So Singapore, again...
You say that it incorporates Article 12.
Yes, we can turn it up, my Lord, if that would help.
But it's sufficient that part of the Act took place.
But it has a physical presence requirement as well.
Oh, I see.
Yes.
We don't
because Article 12 has
that. You have to look down to footnote 7 to see that.
Yes. If you turn it up, it's actually literally a cut and paste, I think, pretty much exactly of Article 12. And the timing, as I say, is that they signed it 2007, yes, enacted the law, and then ratified it 2010. So that's all that's about. Singapore, again, if you look at it, it's essentially just adopting the UK model. Again, there's no case law on it. And in South Africa, the same. It's adopting the UK model, no case law. And Spain, again, is adopting essentially the UN Convention approach, which again requires presence on the territory. So none of these jurisdictions provide any basis for saying that there would be an exception to immunity on the facts of this case. My Lord, notes on clauses, I've only had to refer to it once. You've seen what we say about that. We pointed to the judgment of this court in the Lord Advocate's reference number 1 of 2022 in a unanimous judgment of this court on a reference under the Scotland Act, which took into account notes on clauses relating to the Scotland Act. The court recognised they were not of particular weight, given that they had been drafted by government officials and had not been endorsed by Parliament, but they didn't. But the court did not say they were inadmissible. Whilst we've noted that those notes on clauses appeared to have been published, the court didn't rely on the fact that they have been published in placing some, albeit very limited, weight on them. We say the notes on clauses at least have the same weight as an expert commentary or post-legislative government publication and shouldn't be entirely disregarded.
At what stage were they prepared?
They were...
During the passage of the bill or after?
During the passage of the bill, yes. And you can see that we've been... Then, unfortunately, they're undated, so we've been trying to work out exactly when they were prepared, but you can see that they refer to some amendments having been introduced and others that have been tabled. And we think it's after the 16th of March, being 1978.
So were they available to MPs?
No.
Who sent them? What was that function?
My lord, we don't know. They were found in the National Archives.
Right, okay.
I think the practice in those days was that these are briefing notes, confidential to the ministers.
Yeah.
Okay.
I understand that in relation to finance acts, they tended as a matter of practice to be more widely distributed, but in a sense it's a historical background to, we've now got a completely different system, which is the explanatory note. I think the point you make about the Scottish Act, I need to look at that, but I'm not sure those explanatory notes are notes on clauses. I think that may be the terminology in Scotland for what we now call explanatory notes, but I may be wrong about that.
Yes, I'm not sure about that. It was explanatory notes came in 1999.
Yeah.
And the Scotland Act was just before that. So I think it was...
okay.
Yeah, so I think it was, there were notes on clauses.
Right.
And as I say, those were published.
Yeah.
But that wasn't mentioned in the judgment of this court in placing some, albeit very limited.
I mean, there is this slight wrinkle, I think, with the notes on clauses that you are relying on, that they are technically confidential, I think, at the time to the ministers. But
my lord, yes. And so we say, at the very least, they have such weight as you would give a textbook, or if they had subsequently been published. I mean, they're not... they perhaps provide some explanation, but then they're not.
you say they're admissible, and whatever weight we place on them has to take account of the fact that they...
Exactly, my lord. And it will be
were limited.
I haven't placed any significant weight on them. And I haven't.
Well, it may be no objections taken, as I understand it, in any event, but that may just have been to hearing them de bene esse, I don't know. Yeah. Right.
So that brings us finally to the respondents' notice point. By their respondents' notice, the respondents admit that if Section 5 applies to the present case, then this would breach their right of access to a court protected by Article 6 of the European Convention, because it would represent a procedural bar on access to the court, which is not justified. This respondent's notice point, it's important to emphasise, proceeds on the basis that we are correct, of course, with our primary submission. So if we're correct and Section 5 does not apply, it is said that would be a breach of Article 6. And we say that is not correct, and indeed we say the submission is inconsistent with the Ben Kabouche judgment. We've already been through Ben Kabouche at some length, but we say that it is authority for the proposition that states are entitled to immunity under customary international law for claims relating to acts jure imperii. And in the absence of any special rule of international law conferring jurisdiction in respect of such acts, the application of a rule of immunity is justified for the purposes of Article 6 of the European Convention on Human Rights. Since this claim does relate to acts Uriae Imperii, if Section 5 is read in the way that we say it should be, there can be no breach of Article 6 of the European Convention on Human Rights. Now, I've taken you to paragraph 34 of Ben-Kabouche already, which says that the relevant rule of international law is that foreign states are immune. If foreign states are immune, then the forum state is not just entitled. In fact, no, I'm not sure we have looked at this point. I'll just take you to it in case we haven't. So this is 695. Just give me that. So it's paragraph 34.
What is it?
I'm sorry. Ben-Kabouche, 6.
Oh, right.
9, 4.
Yes.
Can I ask you just to read paragraph 34? It's quite a long paragraph. My Lord, so you see in the centre of that paragraph at C, what justifies the denial of access to a court is the international law obligation of the forum state to give effect to a justified assertion of immunity. So we say that the obligation springs from the default rule of immunity for acts Uriae Imperii, and that is an answer to the Article 6 claim, because there is an obligation under international law to give effect to the immunity of my client. Now, we also say that is required by Article 15 of the European Convention on State Immunity. But of course, since my client is not a signatory to that convention, we can only rely on that, as it were, by analogy. It's clearly within the remit of the United Kingdom to grant immunity to my client, given that it has adopted an erga omnes approach to the application of that convention. But there is undoubtedly an international law obligation, customary international law, on the United Kingdom to recognise immunity in respect to my client, given that there are acts Uriae Imperii engaged in this claim. So in order to defeat that position, the respondents need to show that there is a special rule which creates an exception to the customary international rule of immunity, which is applicable on the facts of this case. And that reference to special rule is taken from the end of paragraph 37 of Ben-Kabouche, which we've looked at.
Paragraph 37,
696, my lord.
yes.
And for all the reasons that I've already given, the respondents are unable to show that there is an exception to the customary international law rule that states are entitled to immunity for sovereign acts that would extend to the facts of this case. Because
what if we had a political assassination case? Do you say then that the court would have to decide the issue that wasn't decided by the international court?
If there was a political assassination case, my lord, the court would then have to decide the issue that was left open by the ICJ. But since this is not a political assassination case, it's a transnational tort claim, the court does not need to resolve that issue. And we say that is the answer to the respondent's notice point. We also say, in addition, if we need to, that one cannot, in any event, interpret Section 5 in any other way than the way we say, if we reach the point that we're right as a matter of domestic interpretation. So on the assumption that we're right on all the arguments I made previously, and that our interpretation of Section 5 is right, it's right because, at least in large part, because it gives effect to the United Kingdom's obligations under the European Convention on State Immunity, and that's what Parliament intended to do. You cannot use Section 3 of the Human Rights Act to interpret a statutory provision in a way which entirely undermines its object and purpose. And can I just take you to one authority? It's Guyden and Godin Mendoza, which is at 951 of the bundle. Facts of the case concerned interpretation of the Rent Act. So it doesn't matter for present purposes.
2951.
It's the authority is at 951.
So sorry.
This is the leading case on what is possible, isn't it?
Yes, there's
Going
another
against
case we
the
referred
grain
to.
and all that sort of thing.
Yeah, exactly. There's another case, Sheldrake, which also refers to the principle, which is the judgment of this court. But either one. And if you turn to page 966 within the judgment of Lord Nichols, paragraph 33, Parliament cannot have intended that in the discharge of this extended interpretive function, that's under Section 3 of the Human Rights Act, the court should adopt a meaning inconsistent with the fundamental feature of the legislation. That would be to cross the constitutional boundary Section 3 seeks to and preserve. Parliament has retained the right to enact legislation in terms which are not convention compliant. The meaning imported by application of Section 3 must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the phrase of my learned friend Lord Roger, go with the grain of the legislation. Nor can Parliament have intended that Section 3 should require courts to make decisions for which they are not equipped. There may be several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation. And then finally, at paragraph 35, in some cases, difficult problems may arise. No difficulty arises in the present case. Paragraph 2 of Schedule 1 to the Rent Act is unambiguous, but the social policy underlying the 1998 exception of security for tenure under paragraph 2 to the surviving couples living together as husband and wife is equally applicable to the survivor of homosexual couples living together in close and stable relationship. In this circumstance, I see no reason to doubt that application of section 3 to paragraph 2 has the effect that paragraph 2 should be read down. So what it's saying is that the interpretation they're adopting goes with the grain of the legislation, goes with the underlying thrust of the policy that underlies the legislation. But if I'm right on my submissions on section 5, that would not be the case here. Because if I'm right on my submissions on section 5 is giving effect to the European Convention on State Immunity and ensuring that the UK complies with its international obligations. And you could not use section 3 to essentially pull it in an entirely different direction and undermine that core purpose.
So the most you say would be a declaration of incompatibility, would you?
That's not been sought by law. Unless there are any questions, further questions, those are my submissions.
Thank you very much, Mr. Hickman. We're grateful. Mr. Rossi.
Thank you, my Lord. My Lords, my Lady, the respondents submit that the Court of Appeal reached the right conclusions for essentially the right reasons. We make three core submissions. First, the natural and ordinary meaning of the words in Section 5 is indeed clear and unambiguous, both taking the words in isolation and viewing them in their wider statutory context. The meaning is precisely as found by the Court of Appeal in the second sentence of paragraph 54 of its judgment. A foreign state does not have immunity for personal injury caused by an, emphasize an, act in the United Kingdom, even if other causative acts take place abroad. Secondly, and importantly given the emphasis of the appellant's submissions, that clear and unambiguous meaning is not altered or displaced by the terms of the European Convention on State Immunity or by any other sources of international law, including the principles of customary international law. If the words are in truth clear and unambiguous, as the Court of Appeal, we say, correctly held them to be, then it is, as Lord Bingham put it in Jones, the straightforward duty of the Court to apply them. But if anything, we say, the meaning identified by the Court of Appeal is reinforced by three matters flowing from the European Convention on State Immunity and from international law more broadly. First, there is the marked divergence as a matter of language between Section 5 and Article 11. That shows a deliberate departure from the terms of Article 11, and it is Parliament's will, as expressed in Section 5, which falls to be applied. Secondly, the scope for divergence permitted by Article 24 of the European Convention on State Immunity disposes, we say, of any potential problem of breach, which would anyway fall to be addressed on the international plane. And thirdly, the principle of territorial sovereignty expressly identified and emphasised by the International Court of Justice, by this Court, and by the Court of Appeal in this case, as one of the twin principles underpinning the law of sovereign immunity, underscores, we say, the conformity of the Court of Appeal's interpretation of Section 5 with customary international law. And to directly answer the question communicated by the Registry on Monday of this week, there is in particular no requirement to grant immunity in proceedings in respect of personal injury caused by an act in the UK where the act is a sovereign act.
Could you repeat that
There is
proposition?
no requirement to grant immunity in proceedings in respect of personal injury caused by an act in the United Kingdom where the act is a sovereign act, save where that act is an act of the foreign state's armed forces and other organs of the state in the conduct of armed conflict. And it's important...
I'm sorry, I'm going to that's an important proposition that we're going to have to think about, so I can just have the precise form of words again, please.
So there is no requirement to grant immunity in proceedings in respect of personal injury caused by an act in the UK where the act is a sovereign act, save where that act is an act of the foreign state's armed forces and other organs of the state in the conduct of armed conflict. And it's important to emphasise in this context, before going to my third
Armed forces and other
organs of the state in the conduct of armed conflict.
And will you have an example to show us where a claim has not been found to be immune before this one?
No, my lord. I'm going to rely upon the words of the Act, and I'm going to say, and this is the point I was going to make, it's important not to make the same error as the Secretary of State made in Benkabush and take the wrong starting point for the analysis before this court. The correct starting point, we say, is that a state will be entitled to state immunity in respect of some, but not all, acts of a sovereign nature. That's the correct starting point. And we know that's the correct starting point because, albeit expressed in different ways, there are instances of a territorial tort exception reflected in the treaties, reflected in the legislation, reflected in the case law, including within the United States. The Letellier case is a classic illustration of that. It's a sovereign act, but it does not entitle or to give rise to an obligation to afford state immunity. So that's the correct starting point. And then the second material question is whether, it's the question posed by the registry essentially, whether customary international law requires immunity in respect of sovereign acts occurring in the forum state and causative of personal injury.
I'm sorry, you're going to have to repeat that.
The material question, my lord, is whether customary international law requires the grant of immunity in respect of sovereign acts occurring in the forum state and causative of personal injury. And we say the only relevant content of customary international law in that regard is that it does require it where it's concerned with the conduct of armed forces or other organs of the state in the course of armed conflict. So we actually say that it's really for Bahrain to establish a principle of customary international law requiring the grant of immunity in this case to give strength to its argument. Mr. Hickman, for forensic reasons, understandably sought to cast the burden repeatedly on me in that regard, and that's, we say, a flawed analysis. So that's the second core submission. We've got clear and unambiguous meaning first. We've got no obstacle to that application, the application of that meaning as a result of international law, whether it's EWCA, whether it's customary international law. And then the third core proposition is that applying that clear and unambiguous meaning to the respondent's allegations in the present case, the Court of Appeal was entirely correct to conclude at paragraphs 26 through to 47 of its judgment that these proceedings are indeed in respect of personal injury caused by an act, or indeed acts, in the United Kingdom. As the case law from other areas cited by the Court of Appeal and by Mr. Justice Knowles at first instance, never addressed by Bahrain, either in written argument or today illustrated, I'm talking about Levin and Ashton Investments, any other conclusion would be artificial and unprincipled. and it's, with respect, an outcome entirely meriting those adjectives if the infiltration of computers situated in the United Kingdom, the extraction of data from computers situated in the United Kingdom, the interception of communications on networks in the United Kingdom, and the carrying out of video and audio surveillance in the United Kingdom at the respondents' homes did not constitute the carrying out of acts in the United Kingdom. Now, there was a lot of reference to...
But you would accept that that is a line drawn by Article 11 of the European Convention?
I would, my lord, yes.
So it can't be so unprincipled, can it? Or do you just say that...
I'm sorry, my lord?
It can't be so unprincipled if that is the basis of an international treaty, can it? Or do you say it is?
Well, I say it gives rise to arbitrary consequences, my lord, but I also say that your lordship, with respect, shouldn't rest your analysis of the European Convention on State Immunity simply on Article 11. You also need to have regard to Article 24.
Do you say that all cross-border effects come into that category, or is there something particular about speed at which it happens with computers? I mean, the posted box of chocolates, is that in the same category as this?
Well, I challenge the premise, first of all, my lord. I don't accept that this is simply characterised as cross-border, trans-border, tortious conduct.
What I mean by that is there's no human being situated.
There's no human being situated here, my lord, no.
A human being does something somewhere else which has consequences here.
Yes, my lord.
And you say it matters how closely linked they are in time, so when the computer person moves his mouse, something almost instantly happens on the other side of the world, or, I mean, there's the telephone call perhaps is in that category, is it? But a letter that arrives is slower, is that, is that in the same box or a different one?
It's a different one, my lord. This technology allows real-time access to data, to information, and to control of surveillance within the United Kingdom. That is very different to someone posting a letter and not knowing whether or not it would appear in the United Kingdom. It's odd in some ways, given the power of this technology, to see a state acting in some lesser way in the United Kingdom, using means of control of this kind, than it would by sending operatives to the United Kingdom who might or might not be successful in their intended task of, to use the example we've been discussing already, assassination.
And you get that distinction out of act or omission in the UK. You say, oh, well, that really means instantaneous, or more or less instantaneous. If it was a letter or poisoned chocolate, you say, no, that's different.
Well, we'll come to that in due course, my lord, but Lady Fox, certainly in her article, has no difficulty ultimately with the idea even of the letter bomb falling within Section 5, because she characterises the act as actually being completed.
I'm just trying to work out your submission in answer to my Lord Legate. I understood you to say that it is different if you've got more or less instantaneous effects, so to speak.
You've got not just instantaneous effect, but you've got the ability to control constantly, in real time, what is or is not occurring in the United Kingdom.
So that's a necessary element, is it? That you can adjust your actions accordingly. Pressing a button to send a missile wouldn't count, because the missile once launched is, let's say, not one that you can control. Some can, perhaps. Well, okay, so it would make a difference, would it, if you could control the movement of the missile in flight, but not if you can't?
Well, to deal with that answer, that first, Lord, and you've seen reference to the ILC's articles or in relation to Article 12 of the UN Convention on State Immunity. Though that commentary made it clear that the express presence requirement was necessary to exclude trans-border conduct of the kind my Lord's been putting to me. So that commentary actually assists us, because we don't have that presence requirement in the domestic statute.
Well, no, but you have to spell out of the word act some distinction, and at the moment I'm just trying to get at what it is. I mean, the simple reading, to my mind, is that an act occurs where the human being is who moves his hand. That's the act. And everything after that is an effect. It may be a very instantaneous one, or it may be one that takes days before it causes injury.
We say it is materially different because it is not necessarily confined to the instantaneous effect and the inevitable effect. The installation of the hacking is materially different because it operates in a completely different way. And this is all to do, in the end...
Completely different way from what?
From the pulling of the trigger or the launching of the missile.
Oh, right. So you really are reading into act or omission something along the lines of instantaneous or close to being instantaneous.
I would respectfully submit I'm not reading anything into it, my lord. I'm saying, is there an act in the United Kingdom when someone carries out video or audio surveillance in the United Kingdom?
But I understood you to say that that would be different from somebody sending a letter or a chocolate box with poison in.
It's different, but the same result would be arrived at. We say Section 5 would still be satisfied, and this is the point we make at 42D of our...
So they're all covered?
They're all covered, and we base that by way of support on Lady Fox's analysis.
Sorry, entirely my fault. I'd understood you to be saying that there was an important, significant difference for the purpose of our interpretation of the
act. I don't need them all to be covered because there is a material difference, but we say they would all be covered.
Thank you.
And you say that the ILC reports to which we were referred this morning actually support you because the presence of instantaneous control is available here.
We say the ILC commentary supports us because it explains the inclusion of the presence requirement as being necessary to exclude trans-border torts which would otherwise be within the exception. And that supports us because in Section 5 we don't have the presence requirement.
Sorry, I'm not following that.
Well, my Lord, shall we go to it? It might be easier to illustrate the point if we sorry, let me find the reference.
You say that in Section 5 they clearly have not included a presence requirement.
Yes.
And the whole premise of that part of the commentary was that you excluded transnational shootings, etc., because of presence requirement.
But it's not the only difference of wording from our wording, is it?
No, it's not. It's not, but it's
it might have been needed in that case, but not if the same thing's achieved a different way in ours.
Perhaps, my Lord, but it's the explanation given for the presence requirement in the UN Convention.
Yeah.
It's all premised on the presence requirement.
I'm sorry, my Lord?
It's premised on the presence requirement.
Premised on the presence requirement that trans-border torts are excluded from the UN Convention. We don't have that presence requirement here. So, we say, with respect, in line with the Divisional Court, in line with the Court of Appeal, that it's artificial to characterise the acts actually complained of in this case, extraction of data, surveillance and so forth, as occurring anywhere other than the United Kingdom. Just as...
It'd be helpful if tomorrow you could explain what's meant by artificial, because the word keeps on being used, but I don't find it a much explanatory power, just that word by itself. To call something artificial is to say, well, it would be wrong to not to count it as that. But why? What is the underlying principle?
Because the essence of what's being complained of is occurring in the United Kingdom. The analogy given by the Court of Appeal, and indeed, I think, by Mr. Justice Hurst, sitting as a Deputy High Court Judge in the Ashton case, which we'll come to tomorrow, is to treat what is happening as the opening of the safe. The opening of the safe occurs on any non-artificial approach to the facts of a case like this in the United Kingdom. That is an act within the United Kingdom. That is sufficient to engage Section 5, even if the instruction to open the safe comes from abroad.
If the safe was opened remotely,
Even if the safe was opened remotely,
that would still be
that would still be enough. Just as it would be enough, and this would certainly be technology that would not have been anticipated in 1978, just as it would be enough if there was interference from abroad with the computer of a car, which caused it to crash in the United Kingdom. That would be an act occurring in the United Kingdom. Just as, to give the example we gave in our written case, it will be an act in the United Kingdom to fly a drone into the United Kingdom and direct it to a particular location, causing personal injury.
Well, that may be
a convenient moment, my Lord. Thank you very much.
Thank you, Mr. Rotty. We'll resume at 10:30 tomorrow morning. Court is now adjourned. Thank you very much.
Yes.